Dear friends of arbitration, good afternoon. In this webinar series, we will examine laws and practice of most preferred arbitration jurisdictions. Undoubtedly, one of such jurisdictions is the United Kingdom. Dr. Doğan Gültutan is a senior associate and a solicitor advocate in the Baker Mckenzie dispute resolution team based in London. Doğan acts for and against states and state bodies with particular experience in the energy sector and large infrastructure projects. He also often advises investors on treaty planning and leveraging international protections in the context of government interference. Doğan is dual qualified, both England and Wales and Turkey, and has over 13 years experience before Turkish and English courts and arbitration tribunals. He has been joined the Baker Mckenzie's London team in 2016. His focus in his research is on moral damages under international investment law. His thesis was very recently published by Clever Law International as part of International Arbitration Law Series. Doğan is also a lecturer in law at City, University of London, and has taught and teaches undergraduate and graduate students on international economic law, contract law, equity and trusts law, public law, legal skills, and English legal system. So Doğan will assist us on explaining English arbitration law and practice. Before giving the floor to Doğan, I should thank the Turkish Arbitration Academy for its support. Doğan, the floor is yours.
Thank you very much, Ali Hocam. Thank you, especially for the very generous introduction. It is a pleasure to be here and to be able to discuss English law with you and the distinguished attendees. And again, also, I'd like to double that thanks to the Turkish Arbitration Academy for the invite. Let me just present my slides. Get the slides on board. Can I just confirm that you can all see the slides? Perfect. So this is our, as Professor Yeşiler explained, this is our review of English arbitration law and practice of the last year. And with one exception, I will discuss a case which was rendered down this year, but it has its roots and basis in a case that was delivered last year. But our general focus is in 2023 and trying to ascertain what's happened in respect of the arbitration landscape in the United Kingdom. Let me move to the next slide. So this is how the outline of my presentation will be. So first, we will take a look at the Arbitration Act 1996. There has been an attempt to reform the Act, and a draft bill proposed by the Law Commission is currently before the Parliament, and it is being discussed. So I will take you through. So I will give you an introduction of what the 1996 Act is and what it does. Have a look at the procedure and timeline in respect of the reform that has been proposed, and then discuss a little bit about what aspects of English arbitration law is being suggested for reform. And the second part of the presentation webinar will focus on the cases. And I have four key cases that I would like to take you through. I have, unfortunately, had to be selective in respect of the content of delivery, given the limited time we have. But I am happy to bore you to death with any issues or any other questions or cases you may want to discuss after the webinar or during its Q&A session. So I will try and leave some 10 to 15 minutes at the end so that we can discuss and respond to any questions that are raised. Move on to the next slide. So English arbitration law, as I'm sure many of you are already aware of, is governed principally by the Arbitration Act 1996. It came into force on the 31st of January 1997 and has been in force since then. It has been very little, if any, substantially amended, so it has remained in its form. So this is the first time in 30 years that substantial reforms are being proposed to that piece of legislation. I will refer to the Act as the 1996 Act or the Act simply for convenience purposes. Now, the 1996 Act applies to all arbitrations, domestic and international, and commenced after the date it came into force. It applies to arbitrations that have their seat in England, Wales, or Northern Ireland, but not to those in Scotland. The Scots have their own legislation. Certain provisions of the Act are, however, applicable to foreign-seated arbitrations. For instance, sections 9 to 11 concern the stay of legal proceedings in favour of arbitration. Section 66, for instance, concerns enforcement of arbitral awards, and there is a special separate schedule to the Act which deals with the enforcement of Geneva and New York conventions. So the enforcement of foreign-seated arbitrations in the UK is also governed by the 1996 Act. Section 43, for instance, concerns securing the attendance of witnesses. So if you have a witness who is in the UK and his or her or its attendance is needed for a foreign-seated arbitration, then Section 43 may be utilised to make sure that the witness attends. And finally, of course, non-exhaustively, Section 44 concerns court powers exercisable in support of arbitral proceedings. So if you need English court assistance in connection with a foreign-seated arbitration, then that is also possible. The Act, the 1996 Act, was broadly based on the antitrust model law, with some English approach tweaks to it. The Act adopts, very importantly, a non-interventionist approach, meaning that there is that the Act dictates that the courts do not intervene with arbitral proceedings unless it is absolutely necessary, and this is actually expressly carved out into the statute. So the courts will not intervene with arbitral proceedings unless they have the right and power to do so under the Act. And the Act also grants the parties considerable autonomy when it comes to managing their proceedings together with the tribunal. The Act, as I said, has been largely unamended and since 1996. And in 1996, essentially, the Act codified then pre-existing case law and therefore updated the pre-existing arbitration legislation that was available. That's the introduction to the Arbitration Act of 1996. Now, as I said, reforms have been proposed to this Act. Now, on the slide, you will see the procedural history of the proposal for reform. So in March 2021, the UK Ministry of Justice instructed the Law Commission to conduct a review of the 1996 Act. Now, who is the Law Commission? The Law Commission is an independent law commission set up by Parliament, so the UK Parliament, to keep the law of England and Wales under review and to recommend reforms. Often there would be a sponsoring ministry who would instruct or liaise with the Law Commission to get the ball rolling in respect of reforming a certain area of the law. So the task of the Law Commission, as you can see on slides, was to determine whether any amendments to the Act were needed to ensure that it remains fit for purpose and continues to promote England and Wales as a leading destination for commercial arbitration. Now, this was particularly important after Brexit, because there were fears that Brexit may result in a reduced approach or selection of London as a seat of arbitration. So the government was particularly particularly interested in ensuring that London maintained its top market position in respect of arbitration. The Law Commission, after that instruction in September 2022, published a first consultation paper, and that included a summary of the law as it currently stood, and invited people to comment on the proposals and suggest any reforms. Responses to the first consultation paper was received from the consultees in December 2022, which then followed a second consultation paper from the Law Commission in March 2023. And in May 2023, responses were received to that. And finally, in September 2023, the Law Commission published its final reports together with a draft arbitration bill. So that draft bill was sent to the Parliament for discussion, debate, and adoption. And you've got the link on these slides if you would like to have a look at that final report. It's around 200 pages, but it makes for an easy read, and it's drafted in simple, plain English. So the link is there if you would like to have a look at it. Now, the consultees, who are they? They are individuals, practitioners, academics, and specialist bodies, and major arbitral institutions and firms, both domestic and arbitration. So they all commented on the reforms proposed at both stages. And the consultees' general view was that the Act works well, and that root and branch reform is not needed or wanted. So essentially, not substantial reforms are not necessary to the Act. The Act served its purpose. It does promote England and Wales as a favourable destination for arbitration, but that there were certain issues that needed to be reformed. So minimal reforms were proposed, are proposed. Sorry. Now, in terms of what's happened after the final reports of the Law Commission, together with the draft bill, that bill was then sent to the Parliament, and as you can see on the screen there, that is an extract from the Parliament's summary of the kind of bill's discussion and passage, and it is currently in the House of Lords. So bills generally start in the House of Lords, which is the unelected chamber, people who are experts in their field, appointed to consider and discuss and assist in the running of the kind of Parliament. So the unelected chamber is currently discussing the bill. It's gone through its first and second reading. There was no committee stage, and at the moment it's at the reporting stage. And after the third reading, it will go to the House of Commons, and the House of Commons will take the bill through the same procedure. So 2 readings, committee stage, reporting stage, and a third reading. And some of these steps may be skipped depending on the nature of the amendments proposed to the bill. And then finally, once it has cleared through the House of Lords and the House of Commons, which is the elected chamber where the members of Parliament sit, then it will go through the final stage, essentially ending with a royal assent and therefore coming into force on the date designated. So what are the reforms being proposed, and what are the reforms currently being debated in the UK Parliament? Now, the main reforms are as follows, and there are 6. There are 3 on this slide and 3 that will be in the next slide. So the first main reform proposed is the codification of an arbitrator's duty of disclosure. This is currently case law based. There is no express duty in the 1996 Act. Now, the Law Commission considered that it would be appropriate that such an important duty be recognised in the Act, and that such would be in line with international best practice. So it is merely a matter of codifying the current pre-existing law, not changing it. And the recommendation would be that arbitrators have a continuing duty to disclose any circumstances which might reasonably give rise to justifiable doubts as to their partiality or impartiality. This, in my opinion, is a welcome development, albeit I do not agree that the test for disclosure, as it currently stands and as is currently being proposed to be codified, should be purely objective based. I have a recent article on this topic. If you're interested, please do read that. But essentially, I say that subjective considerations, i.e. the party's legitimate expectations, should also be taken into account where appropriate. The second key reform proposed concerns the strengthening of the arbitrator's immunity around resignation and applications for removal. Now, the rationale is twofold, as the Law Commission explains it. First, it supports an arbitrator to make robust and impartial decisions without fear that a party would express their disappointment by suing the arbitrator. So the Law Commission want to stop cases being brought against arbitrators which do not have reasonable prospects of success, just for the sake of having a second attempt, or providing the disgruntled party with an opportunity to fight once more. Second, the proposed reform, it has said, supports the finality of the dispute resolution process by preventing a party who is disappointed with losing the arbitration from bringing further proceedings against the arbitrator. So again, finality and stopping those unwanted claims. The recommendation is therefore that arbitrators incur no liability or resignation unless the resignation is proved to be unreasonable. And also arbitrators would incur no liability, including cost liability, in respect of an application for their removal unless the arbitrator has acted in bad faith. So essentially, if an arbitrator is reasonable in resigning or has not acted in bad faith and is then removed, then arbitrators are granted immunity from a liability and cost. And I think this is a positive development, but only time will tell how the immunity is applied in practice and whether it works as intended. The third key reform proposed concerns the introduction of a power of summary disposal, save where the parties agree otherwise. And this is to encourage arbitrators to utilize summary disposal, summary judgment-like tools, and make arbitration much more cost and time efficient. An arbitrator is to exercise that power in cases where it is clear that there is no real prospect of succeeding on the claim or issue. So if a claimant has no real prospect of success on the claim or on parts of the claim or issues in the claim, then the arbitrators will be given express powers to summarily dispose those applications and dismiss them. So dispose those claims or issues, sorry. Now, arguably, the arbitrators already possessed these powers as part of their case management powers granted under the various arbitral institutional rules and also in various legislations. But the codification with express terms will hopefully encourage the arbitrators to be more bold and use that power without fear. So it is to a welcome development. The fourth key reform proposed concerns the introduction of a revised framework for challenges under Section 67. Now, there are various components to this line of proposed reforms, and I will not go through each of those, and then they are not exceptionally substantial, but by way of example, one proposal is that new arguments cannot be made and new evidence will not be heard if it is not put before the tribunal when an objection was raised before the tribunal as to the latter's jurisdiction. So if there is a dispute or objection as to the arbitrary tribunal's jurisdiction, then that argument must have been made and run in the case and not held back, kind of banked for tactical reasons to be used later on. The fifth key reform, and the penultimate one that I will discuss today, concerns the introduction of a new rule on the governing law of an arbitration agreement. And this is, in my opinion, the most substantial and the most important reform proposed. The recommendation is that the agreement, so the arbitration agreement, is to be governed by the law that the parties expressly agreed that would apply to the arbitration agreement or clause, not the underlying agreement, or if there is no such express agreement, by the law of the seat. Now, this would replace the NCAT approach, and I'm sure many of you would know that refers to the UK Supreme Court's decision in NCAT Insured and Chubb Insurance, which dictates that the law applicable chosen by the parties to apply to the underlying agreement will govern the arbitration agreement contained within it. So the presumption is that the underlying agreement's applicable law will govern the arbitration agreement, even if the seat is different. So assume the underlying agreement is subject to English law, as was the case in NCAT, but there is a para-seat arbitration. The presumption is that English law would apply to the arbitration agreement as to its validity, etc. But the proposal is that unless the arbitration agreement has an express specific governing law clause, then the law of the seat, so in our case, Paris, the Parisian law, French law, would apply. Now, that the NCAT approach was criticized by the consultees as being complex and unpredictable, and the Law Commission seems to have agreed and therefore has proposed that change. And finally, the sixth reform proposed, the sixth substantial reform proposed, which will be covered in this webinar, concerns the clarification of court powers in support of arbitral proceedings and in support of emergency arbitrators. And essentially, that's an express confirmation that emergency arbitrators can be assisted by the courts. And also, there is a confirmation that the Section 44 powers relating to court powers in support of arbitral proceedings can be made against third parties. That's also a very key development. Now, those on the slide, you can see there are two articles that I've written about confidentiality and arbitrary disclosures, the second one forthcoming. So if you have an interest, you can read those in your own time. Now, in short, what I say in those articles is that I advocate, as I said, for a hybrid test of disclosure, both involving subjective and objective elements, and also in respect of confidentiality, I suggest that there should be a default rule of confidentiality when it comes to arbitrations, whereas the Law Commission has not proposed a reform in that area, and there is no such default rule in the law, although there is a default rule under the case law. I advocate that it should be codified. Now, moving on to the cases. So as I said at the beginning, I've been selective in terms of the cases that I would want to take you through, given the limited time we have, and I have selected 4 cases. This is the first of those 4. So you'll see that there are 3 case references on there because 3 different cases essentially raised the same point, and I was involved in one of these cases myself. So the issue in these cases was whether the English courts have a jurisdiction to grant anti-suit injunctions, called often referred to as ASIs, in respect of arbitration agreements with a foreign seat, so not seated in London. Now, an anti-suit injunction is an injunction that the English courts grant, which is issued in the form of an order to a party, either not to commence or not to take any further steps in proceedings in another jurisdiction, because such would be in breach of the arbitration agreement entered into. Sorry. The arbitration agreements in all of these 3 cases referenced on slides provided for a Paris-seated arbitration. Anti-suit relief, so anti-suit injunctions, ASIs, are not available from the French courts, but the claimants applied to the English courts for injunctions to restrain the Russian court proceedings brought in breach of the respective arbitration agreements. Now, in each case, the arbitration agreements were contained in a bank guarantee bond governed by English law, but provided for Paris-seated arbitration. Now, in each of the cases, the court had to consider whether England was the appropriate forum for the application, given the Paris seat. In 2 of the cases, an ASI, so an anti-suit injunction, was granted by the court, but only by the Court of Appeal in the second one. So at first instance level, that was refused. And in the 3rd case, an ASI was refused. In 2 of the cases where the ASI was granted, the court focused on the unavailability of anti-suit injunctions under French law, and also the connective factors involved, i.e. that England was the jurisdiction which the parties agreed that its laws would apply to the bank bond. And the 3rd court's reasoning is interesting. The 3rd court, and it was an eminent commercial court judge, reasoned that the fact that the French courts might offer different or less advantageous remedies did not mean that justice would not be and could not be done here. So an ASI was therefore not considered as the only tool that could provide justice in the circumstances. The Court of Appeal decision, so as you will see, there are 2 High Court decisions, as you can tell from the abbreviation. So EW stands for England and Wales, HC is High Court. So the last 2 cases are High Court. The first is a Court of Appeal case. The Deutsche Bank and Russian Alliance is a Court of Appeal case. And that was the last in time, and is also a decision of the higher court. And under the rules of precedent under English law, Court of Appeal decisions are binding on lower courts, so high courts, and also future Court of Appeals. So unless the matter is brought before the UK Supreme Court once again, the presumption is that anti-suit injunctions can be granted in favour of foreign-seated arbitration, and that's a crucial development. As I said, I was involved in one of these cases, and it was, and I won't reveal which one of these, but some months back, before any of these cases hit the courts, I was tasked with a legal I was tasked with legal research to understand whether English courts would grant ASIs in circumstances where the seat of arbitration was not in the UK. And I answered that question in the affirmative. Some senior lawyers that I was working with did not, but I was proven right by the Court of Appeal. So the Court of Appeal essentially agreed with that analysis. Now, moving on to the second case, the case of Africa sourcing and société per action simplifiée. Now, this is also an important case, and the reason why I've selected it is because it focuses on arbitrator bias and fairness and disclosure obligations, which is currently a hot topic, and also it was an important decision of the High Court. Again, so you'll see the issue, what the issue before the court in that case was. It was whether the chair of the tribunal was biased, given a long-term, regular professional contact with one of the party's representatives. The matters complained of in that case included the arbitrator and legal representative of one of the parties attending a networking dinner, both having sat on the Federation of Cocoa Commerce's council, and having known each other professionally for 15 to 20 years. Now, the court dismissed the challenge in that case brought under Section 68, which of the 1996 Act, which essentially requires there to be a serious irregularity affecting the tribunal, and that includes a failure by the tribunal to comply with its general duty to act fairly and impartially as between the parties. Now, the court explained that the arbitrator was not under a duty to disclose the facts complained of in that case. Now, in terms of what the test is, the common law test for bias is whether the relevant facts would cause a fair-minded and informed observer to conclude that there was a real possibility of bias. So the test is therefore purely objective and focuses on the what impact the facts would have on the fair-minded and informed observer. The court in that case noted that the dispute arose in a relatively small, so cocoa, commodities market, where traders were likely to know each other, and the trade association's arbitrators were drawn from among its members, and they were also likely to be known to be involved in disputes. So it was a small market, and everyone, the arbitrators and legal counsel, knew each other, but the court found that that was usual and ordinary and not something to be concerned about. And what this case tells us is that an issue as to bias is highly fact and case dependent, and all the relevant circumstances will be considered by the court as part of the objective analysis in this, deciding whether the arbitrator was actually biased. Now, moving on to our third case, this is, as you will see, it's a case that involved the Turkish party. So it's Radisson Hotels and Hayat Otel İşletmeciliği Turizm Yatırım ve Ticaret Anonim Şirketi. The issue in this case was whether a party had lost its right to object on the basis of arbitrator, of an arbitrator failing to timely disclose, timely to raise an objection due to tactical considerations. So in this case, there were claims between Hayat and Radisson in respect of the management of the hotel and the payment of management fees in return. Hayat commenced ICC arbitration in October 2018. It later transpired that the arbitrator Hayat had appointed, who was not a lawyer, was in contact with a Turkish hospitality professional, a Mr. Önkal, who was engaged by Hayat in the arbitration until August 2019. So the arbitrator was in contact with Hayat's counsel in arbitration. In March 2021, the arbitral tribunal issued a partial award on liability and causation, finding Radisson to be liable, among other things, for breach of contract. In January 2022, Radisson sought to set aside that partial award on the basis of secret communications between a party and the arbitrator appointed by that party. The application was made late. This is because such applications have to be made within 28 days under the 1996 Act. It's Section 70. Sorry. And Hayat argued that in any event, even if the application was to be admitted despite its late making, Radisson had lost the right to bring the challenge because under Section 73, a right of the 1996 Act, a right to object is lost if the relevant facts were known, no objection was raised at the time, and proceedings are continued with the relevant party taking part. So if you are aware of a ground for challenge, and you decide not to make that challenge, you bank it for future use in case you need to, and the result is disfavorable, unfavorable to your client or your position, then the courts will not, the Act will not allow that objection to be raised. There is a bar to that objection. You lose the right to object. Now, it seems Radisson was told about the communication between the arbitrator and Mr. Önkal, so the counsel, by a credible witness, through a credible source in September 2021. So that was before the application had been made. And as you will remember, the application to set aside the partial award was made in January 2022. So about 4 months before the set aside application was made, the relevant facts were known to Radisson. But Radisson took a strategic decision and to bank it for later use, while continuing to participate in the arbitration in the hope of obtaining a favorable outcome. The court held that Section 73 applied, and Radisson was precluded, so not allowed, by that decision, by that section, from raising its grounds of objection to the partial award. So Radisson could no longer object to the partial award on that basis. And this is a cautionary reminder to object timely and not to delay your objection for tactical considerations. It could very, very well backfire in a serious way. Now we move on to our final case to be considered, to be discussed today, and that is the Border Timbers Limited and the Republic of Zimbabwe. That, as you will see, is a High Court decision of the courts in England and Wales, and it was a decision of the Commercial Court. The issue in that case was whether respondent states, so states who were against whom investment proceedings had been brought in exit cases, could raise and could rely on state immunity grounds to successfully resist enforcement of that exit award against it before the UK domestic courts. Now, as I said, this is not a case from 2023, so technically it should be out of scope. But I wanted to stretch the rules a little and speak about this case. And also, there is a connected tide case, which was delivered by the Commercial Court in 2023. And both of those cases will be heard by the UK Court of Appeal together. So in June, we will have a 4-day hearing to determine where the Court of Appeal will hear both cases because they raise similar legal issues. This is on the back of an exit arbitration. So Border Timbers and others, two other group companies, commenced exit proceedings against Zimbabwe and ultimately obtained an exit award for compensation or restitution, failing which compensation to the tune of $125 million plus interest, and interest has been continuing since 2015, so it is a substantial sum, and it was in connection with the expropriation of farmland, agricultural farmland. And this case is I have been dealing with this case for several years now, and it has reached the commercial court level. And we recently, well, in January, we had so the hearing was in December, and in January we had our judgment delivered from the commercial court. Now, the important takeaway from this decision is that English court, the commercial court in this case, held that state immunity does not apply to application to register exit awards on the basis of the civil procedure rules, which apply to civil litigation in England and Wales. So the court's reasoning was that if you are making an application to register the award, then that is not subject to state immunity because you are not enforcing the award, you are simply registering it. But when you take steps to register, so take steps to enforce by way of execution, then state immunity arguments could be raised. Now, there was another first instance commercial court decision delivered by Mr. Justice Fraser last year in a case called Infrastructure Services against Spain, and that's a claim against Spain. Of course, that case concerns certain European law issues following from ACMEA. But in that case, Mr. Justice Fraser found that state immunity arguments could not be raised, and it could not be relied upon as a defense to resist enforcement, purely because the exit convention is final and should be enforced as if it's a final decision of the English courts, and also that there is relevant submission to jurisdiction and or arbitration jurisdictional submission, which are two exceptions to state immunity under the English State Immunity Act 1978, and therefore found that although the result is the same as was the decision in Border Timbers, it was for different reasons. Now, as I said, these two cases have now been appealed. Infrastructure Services Luxembourg, the Spain case was appealed first, and that was given a June hearing date. And our case will be has been decided to be merged with that case. So we will have 4 days of hearing to discuss whether state immunity defenses could be used to resist exit award enforcements. But for the time being, both Mr. Justice Fraser and Mrs. Justice Dias in the Border Timbers case held that they could not, but for different reasons. And it is hoped that the Court of Appeal will clarify the law on this area and align the legal rules and requirements relating to the enforcement of exit awards in the United Kingdom. Now, that is the end of my presentation. I hope you have enjoyed it. Thank you very much to you all, and especially to the Turkish Arbitration Academy and Professor Işılırmak for having me. I am open and happy to answer any questions you may have. And I have left some time for that. So please do raise any questions. I hope to have a free-flowing discussion now that I've gone through the dry bits of the webinar.
Thank you very much, Doğan. It was joyful indeed. There are a number of questions. One of them would be on the last subject that you mentioned. How do you think the Court of Appeal will decide the border appeal? Will exit trump state immunity?
Hocam, that's a very good question. I think it will. Now, it's noteworthy that in both cases, the judges held that the State Immunity Act 1978 did not apply, and therefore Zimbabwe and Spain, in the respective cases, could not rely on immunity to resist enforcement. But of course, for different reasons. Mrs. Justice Dias's decision in Border, in our case, was on the basis of a technicality in the civil procedure rules. But Mr. Justice Fraser took a different approach and concluded that when the parties who have signatory to the Exit Convention have agreed to submit to the jurisdiction of the other in respect of exit award enforcement, and unofficially and in legal circles, it seems that Mr. Justice Fraser's reasoning is likely to be upheld. So although both judges have decided that the immunity defenses do not apply, I think that Mr. Justice Fraser's analysis will hold tight in the sense that exit will trump state immunity, and exit awards will be treated differently from, let's say, New York Convention awards. And New York Convention awards may be subjected to immunity grounds, but given the language in the Exit Convention around submission to jurisdiction and enforcement of awards in local jurisdictions, I think exit will ultimately trump state immunities.
Thank you very much, Doğan. I have another question about the arbitration bill. Do you know if there's any rule on third-party funding in the arbitration bill?
I know there was a discussion as to whether third-party funding regulation should be introduced. But from memory, I think that it was decided that it shouldn't be, and that the matter should be left for the market to decide and address, and that the cases should kind of respond to the various forms of agreements there are. So I'm not. I don't think there are. And from memory, I think that's the case, but I'll have to double check. But I don't think it is something that is within the scope of the reforms.
Thank you. By the way, when do you think the arbitration bill, receive royal assent? Is there any estimated date?
Hocam, there's no estimated date. It's very impossible to tell, but the Law Commission reporting and consultation process was very speedy. So people were amazed as to how quick the Law Commission was able to deal with it and send a bill to the Parliament. My guess is that by the end of the year, we will have a bill approved by the Parliament, especially given that it has already almost finished its phases in the House of Lords. So it's only the House of Commons, and the reform proposed, as I said, are not very substantial or groundbreaking. So I don't suspect there to be a lot of amendments or a lot of debates and discussions in the Parliament. But that said, as you may know, England is gearing up for a general election this year. We don't quite have the exact date. So if that does happen, that could impact the arbitration bill's delivery date by a huge margin. So subject to the election, the adverse impact that the election may have on the bill's discussion and approval. I think by the end of this year, we might have it royally assented by His Majesty King Charles.
Thank you, Doğan. One last question perhaps is on emergency, rule on emergency measures. You mentioned that there's a rule on emergency measures in the bill. So if it is accepted, would you think that that would help decreasing applications to the court on emergency measures?
I think it would certainly help. As a practitioner, I think the English courts have already been pragmatic and realistic in their approach in assisting arbitrary tribunals in terms of the enforcement of interim measures and the like. And that has, to my knowledge, been the same in respect of emergency arbitrator measures ordered, whether it be granting the same remedy or rehearing and re-granting the remedy that the arbitrators had granted. But as a practitioner, I think it's highly likely, and I myself would react to it in the sense that if there is an express recognition of the court's power to assist emergency arbitrators, then that would increase the use of emergency arbitration and increase the references to the courts in connection with those emergency arbitration proceedings. So I think that is highly likely.
Thank you very much, Doğan. There seems to be no more question. This webinar is brought to you by Ibn Khaldun University Dispute Resolution Center. So we are grateful to our team, Associate Professor Dr. Yeliz Bozkurt Gümrükçoğlu, Dr. Ömer Faruk Kafalı, and our assistant Hüseyin Yağsankol. Thank you very much. We are also grateful to our team for preparation of flyers and etc. And lastly, we are grateful to Dr. Doğan Gültutan for its short but true presentation of English law and practice for 2023. I hope to meet with Doğan in his presentation for 2024. Thank you.
I very much look forward to it, Hocam. It has been a pleasure to join you. So thank you again for the invite, and I wish